Hello, defense attorney Mark Rosenfeld here. I want to talk about a common question I get from clients or clients' family as we're approaching trial or going into trial, and that is, should the defendant, should my client, testify at the time of trial? And I'll tell you the general rule that I have is no. The client should not testify. In very limited situations, we may decide that they should testify, but usually I will say no. Now, ultimately, it's not my decision as the lawyer. It is the client's decision on whether they want to testify or not, and they have an absolute right to testify if they want to. But a few things to keep in mind. First, you have the right to remain silent. That right to remain silent continues from the beginning to the very end and includes the trial. You do not have to take the stand and testify, and that right to remain silent only works if you use it and choose to remain silent. There's a lot of things that can happen in trial, and testifying is a very stressful, very difficult situation. So using the right to remain silent is very important. Oftentimes when we're picking the jury, I will cover this topic with the jurors and ask them, do they want to hear from the defendant, from my client? And a lot of times they'll say yes. And then other jurors will say no, or they don't care. But when we go into it a little deeper, we'll see that there's one group of people that say, yes, I want to hear what the person has to say because it's their case, it's important. But then other people will say, well, yes, but we're not really going to trust anything the person says because they're only going to say things that are going to help themselves. So if they testify, they're biased and they're lying, and if they don't testify, then we didn't get to hear from them. So that's why the law says that they have a right to remain silent, and the judge will instruct the jurors that they should not consider for any purpose if the person does not testify. So one thing, right to remain silent, talk about it with the jurors in voir dire when we're picking the jurors, and then make that decision when it's appropriate, and usually it is to remain silent. Another reason that I would say that a client should not testify is that anything that they say can be used against them. Someone can testify and they can add information or give testimony in such a way that is misleading or can be twisted around. Keep in mind that through this process of taking the witness stand, it's not just a direct examination where the defense attorney asks friendly questions of the defendant, of their client, and the client gets to tell their story in a nice, friendly environment. Part of it is direct examination where we can discuss, rehearse, and prepare for trial. But the other half is cross-examination, where a skilled and trained attorney for the state, for the prosecution, will get to slice and dice and ask very pointed questions and try and trip the person up who's on the stand, make them look like they're lying even if they're not lying, and can leave an impression with the jurors that the person testifying was less than completely honest. So the defendant testifying can, through direct examination, be very helpful, but then through cross-examination look pretty bad. In addition to the direct and cross, we want to look at why that person is testifying. If the client feels that they need to take the stand and testify, that means there's some part of the story that explains what's going on that hasn't been explained. And we really want to take, in preparing the case for trial, and look into this issue and see, can we get this information out another way? Are there other witnesses, either prosecution witnesses or other defense witnesses, that can come to court, can be subpoenaed to court, and be required to testify to be able to explain who, what, where, when, why, how? We want to get the full story out, and we want to do it without having to put the defendant, without having to put my client on the stand. And usually there's someone else who can lay that foundation and can come to court and explain that. We also want to make sure that if the defendant does take the stand, that they don't say anything that would perjure themselves. If they testified previously at a hearing or filled out paperwork under penalty of perjury, under oath, we don't want something coming out in trial That could be a new charge of perjury or just be misleading, and someone says something and it's interpreted differently, or the police officers wrote it down one way and now it's something else, or something was recorded and said out in the field and the person didn't remember that and said something different in court. The memory is fallible and people are not perfect, and someone can be completely honest and trying to do the right thing and have it be misinterpreted. Another reason that I would say I do not want my clients to testify is if things don't go our way and a jury decides, hey, we believe that the defendant did at least one of the things they're charged. Many times prosecutors will charge multiple offenses. They'll say, we believe that the defendant did these 5 or 6 different things, and the first couple of things are really reaching and the person didn't do those, but maybe the 5th or 6th thing, maybe they did do that. And if the person testifies and they win counts 1, 2, 3, 4, and 5 with not guilties, but on count 6 they are convicted and found guilty, the judge can use the fact that the defendant testified and say, look, you testified, you were not honest, the jury believed on this particular charge you were not honest, and therefore I'm going to punish you, not what we talked about before trial, but I'm going to punish you more because you lied when you came into my court. At least I've seen judges interpret testimony that way and say, because you testified this way and the jury didn't believe you, I'm going to give you a harsher sentence. Not all judges will do that, but I've seen it happen more than once. So as a general rule, I'm going to say, should you take the stand and testify in your own defense? Probably not. Are there certain circumstances where I have a particular client with a particular set of facts? Maybe. But most of the time, I'm going to say you have a right to remain silent, use it, force the prosecution to prove it beyond a reasonable doubt. If the prosecution doesn't prove it, you're entitled to a not guilty verdict, and you don't have to put yourself on the stand and expose yourself to the stress, the aggravation, and the uncertainty of testifying at trial. If you've got questions about trial or any criminal matters in Southern California, my office is located in Beverly Hills, and you can reach me at 310-424-3145, 310-424-3145.